blindfolded and handcuffed and made to kneel on their knees most hours of the day in open-air cages on the ground, this is not an incident. This is the policy. This is the way people have been held under military orders for months and months and still are.
Medieval crimes are being committed.
I come with clean hands.
Victims of horrific crimes want justice.
We don't have anything better than this.
This is Asymmetrical Haircuts, your international justice podcast, with Janet Anderson and Stephanie van den Berg. This episode was produced in partnership with justiceinfo.net.
All rise.
Hi, Steph.
Hi, Janet.
Well, since October 7th, when more than 1,000 Israelis were killed in an attack by Hamas and other armed groups, the Gaza Strip has been the focus of Israel's counterattack to, quote, destroy Hamas, it says, and, quote, release the more than 200 hostages taken there.
Now, we've covered in previous podcasts how the killings and bombings and sheer destruction of the Gaza Strip, with now up to 40,000 people dead, according to Hamas Health Services, in the last 10 months. And those things have been presented in arguments about the application of the Genocide Convention at the International Court of Judges, and the judges there ordered provisional measures.
And we've also covered, in quite some depth, I would say, the International Criminal Court prosecutor, Karim Khan, his application for arrest warrants, including against the heads of Hamas and the Israeli Prime Minister and the Defense Minister.
And now we want to look at the Israeli justice system and what's been happening in the prison system there. This episode comes with a trigger warning. I would say lots of trigger warnings. We will be discussing some examples of alleged Israeli torture. We're trying not to be gratuitous, but it really is needed so that everybody knows what we're talking about.
And we're really focusing here on how Israel has responded not only to the ICC investigation, but to allegations against its forces, which certainly I've been conscious of for the last 40 years or so, which have come up in many fora, and what that response actually means in terms of any arguments that it might present back in The Hague about complementarity, which is the idea that by investigating themselves, they don't actually need the court's intervention. And also what role the Israeli justice system itself has been playing in this kind of acceptance of torture as part of the system over these years when it comes to conditions for Palestinian detainees.
So we have a lot to go through, and joining us is Tal Steiner of the organization Public Committee Against Torture in Israel. Hi, Tal.
Hi, hello.
So, Tal, can we kick off with what's currently being alleged, particularly in the post-October, the last 10 months world, and then we'll try to provide a bit more context into how Israel responds to those allegations and what that response tells us. So what's being alleged at the moment?
So in this sphere of detention and treatment of detainees, which is our expertise, what we have seen since October 7 is a crisis unprecedented, both in its scale and in its gravity. With scale, we're looking at double the amount of Palestinian detainees than any other time since the beginning of the occupation. We're talking about almost 10,000 Palestinian detainees from both the West Bank and the Gaza Strip. It's almost 3 times the amount of normal years. Of them, we've seen 40% administrative detainees. And we have seen the phenomenon of this new legal definition, the unlawful combatants, which all Gazan detainees fall under. And I'm sure we'll be discussing in great detail how that affects their rights. So this is the scale, and scale leads to severe human rights violations. And here we go to the gravity. We've seen extreme overcrowding in the prisons, the facilities administered by the Israeli Prison Service, which led to shortages of food, of electricity, of sanitary, of medical assistance. And we've also seen repeated systemic physical abuse by prison guards that has never been that way before. We've had very few instances of that yearly, and now we have dozens and dozens of such testimonies. And lastly, we have the military detention camps. And there we've seen things that we've never seen before, and as an Israeli, hoped never to see. We've seen and documented people held in open-air cages, blindfolded and handcuffed 24 hours a day, suffering extreme medical conditions without proper attention, physically abused, sexually abused, interrogated, under torture. In fact, all of those detention conditions, even without being directly assaulted by soldiers or by prison guards, to itself amounts to torture and ill treatment. And this is this crisis that we are facing since October 7 and is still ongoing.
I want to dive a bit deeper in some of the aspects you've mentioned, and we're going to go through most of the things that you've said already. From the UN, we've also seen these allegations of widespread abuse of prisoners being held incommunicado, in arbitrary prolonged detention. They're talking about thousands of Palestinians, including medical staff, who they say have been taken to Israel, usually shackled and blindfolded. You mentioned some of these things already. I didn't catch a number for the amount of prisoners that you said. Can you say how many security detainees, as Israel calls them, there are now, or what the estimates are?
Of course. So Israel currently holds, only in the prison facilities, namely not in the military camps, 9,844 detainees. Okay? Of them, administrative detainees, 3,323. So a huge amount, almost 40% of the current detainees are administrative detainees. But I want to highlight also the figures relating to the detainees from Gaza, because that's a newer phenomenon. So according to the information provided by the state during our litigation at the Israeli Supreme Court, we've learned that Israel has detained 4,000 detainees from Gaza. Of them, almost 2,000 have been released back to the Gaza Strip. Israel currently holds around 2,300 Palestinians from Gaza, and around 700 of them are still held in the military camps, while the others are held in prison facilities. Interestingly, the notorious Sde Teman camp, which was brought to the highlights in many instances, currently holds 24 people out of the many thousands of people who have gone through Sde Teman, where most of those very difficult conditions have been reported. Most of them are no longer held there. Only 24 people remain. The majority of them is held either in another military camp, the Ofer camp, or spread out in different IPS facilities.
In terms of some of the conditions, you've detailed some of the kind of general abuse, but one thing in the reading that struck me is the level of secrecy, the level of not having access to lawyers, not knowing where they're detained. Is that absolutely prevalent? Is that the norm? Or is that just a few cases?
So again, we have to differentiate between Palestinians from the West Bank who are held as security detainees. Of course, their rights fall much below the standard for criminal detainees, Israeli citizens. But there we maintained access as lawyers throughout the war since October 7. It was more difficult, mostly due to the overcrowding and IPS efforts to handle that amount of detainees. But we were able to visit with them. The ones who weren't able to visit with them since October 7, of course, the ICRC. Israel has banned access of the Red Cross Committee to all detention sites, IPS and military, since the start of the war, and is upholding that decision still today. With the detainees from Gaza, there is a different story. Firstly, for the first few months, nobody had access to the military camps. Israel would not release any kind of information about how many people are held there, not in their identity. You actually could not have located a person for the first few months. If a person has gone missing in Gaza, his family had no way of knowing if that person is actually detained, held by Israel, dead or alive, none of that. Because of our litigation and the constitutional challenges that we've brought to this unlawful combatants law, the legal framework that allows for holding people in such incommunicado state, slowly, gradually, the timeframes for holding people in denial of counsel, not allowing their families to locate, to trace them, all of that has gradually changed. And so currently we are able, through a lot of difficulty still, but we are able to locate certain detainees. If a family from Gaza tells us our family member is gone, here is his name and ID, then most probably we would be able to locate him if he is indeed detained by Israel. And for those who've been detained long enough, it's funny to say that way, but for those whose time period of 75 days denial of counsel has passed, we would be able to visit with them. It's difficult. Each lawyer visitation takes a long time, but we are able to start visiting with them. And then this is crucial because it means that we can collect testimonies, that we can get power of attorneys, that we can assess medical situations, that we can start filing complaints of abuse and mistreatment. And I would say each detainee that we have visited has repeated the same allegations. So everything that we've seen on international media that has been reported by people who were released back to the Gaza Strip and then could tell their stories, all of that has been corroborated by the testimonies that we've collected ourselves.
And before we go back into some of the testimonies of what people say has happened to them, one of the things that you mentioned here is that I understand already there's a kind of two-way system in Israeli law for Israeli citizens and maybe people from the occupied territories. And now what you're saying is there's also a different treatment from people who are security detainees, from people who are classified as unlawful combatants. So can you explain these levels of what that is different? Do you already have different treatment of just generally Palestinian prisoners? And then within that different treatment, there is more differentiation now because of the conflict and the way that the judiciary is dealing with it?
Yes, we can definitely say that Israel has, you would say, invented a third legal system for Gazan detainees, different from what Palestinians have endured so far and very different from what Israeli citizens have to deal with. The unlawful combatants law is not new. It was legislated already in 2002. A copy and paste of the American notion of unlawful combatants used to hold people in detention camps like Guantanamo. Basically, what this law does is to strip such detainees from both their protection they would have been awarded as prisoners of war, because Israel alleges that such protections cannot be awarded to people who are not members of a regular army, but rather of militias, armed groups, terrorist groups. You can choose the definition, but Israel denies them the privileges of prisoners of war. But on the other hand, denies them the protection of a protected population under humanitarian law. Because according to Israel, Gaza is not under occupation. This law used to apply, for example, to Hezbollah combatants from Lebanon that Israel had. This law has been challenged at the Israeli Supreme Court by PCATI. In 2008, the court upheld the law, but said in its initial, very, very initial form to say that the measures, the procedural difference that this law allows, and we'll dive into that in a moment, can only be a maximum measure in emergency situation, in wartime situation. So what happened to the law since October 7? If the unlawful combatants law used to say that within 96 hours of detaining a combatant, the military commander must issue an arrest warrant, deciding that this indeed is an unlawful combatant that has individual risk emanating from him, that time frame is now at 30 days. So from 96 hours, we've jumped to 30 days. And I would say in the middle, we had a higher jump. This is only after litigation that we've been able to lower that time frame. Judicial review, according to the unlawful combatants law, a person who has been declared an unlawful combatant and an arrest warrant has been issued should see a judge. It used to be within 40 days. Now that stands at 45 days rather than 14 days. Denial of counsel, which is a huge issue for torture prevention, used to be allowed for 10 days and now stands at 45 days. So we've seen huge gaps between what security detainees are awarded, security meaning Palestinian detainees. I'm sorry, this is just the Israeli lingo around that. And of course, much different from normal criminal arrest procedures that we know. What we have argued repeatedly, and I'm glad to see that this argument has also been accepted by, for example, the Special Rapporteur on Counterterrorism, is that this law denies such basic procedural safeguards that it indeed builds the ground for the abuse that we've seen later on to happen, because it leaves people outside the protection of the law for so much time that literally anything can happen to them and it would go unaccounted for. And the second argument that we've brought forward is that this legal reality in itself constitutes the war crime of enforced disappearance, because it leaves people without any kind of account for them, for weeks. And this in itself is an abuse of human rights, even before we go into what happens to them when they're so far from sight and out of contact.
We did a podcast with the UN Special Rapporteur on sexual violence, where she at that point sort of mentioned the allegations specifically of sexual violence against the Palestinian detainees. And now I've been reading some of the reports from the UN about the kinds of degrading treatment that people have faced, about the use of metal sticks to penetrate somebody's rectum, about wearing nappers, about electric shocks, about the stripped naked. I mean, you've just said that you are taking testimonies and your testimonies confirm. Are you part of a larger system of people who are trying to gather the testimonies of all of these individuals and get them out into the public? And do they all point in one direction?
Yes and no. I mean, of course, we are a part of an Israeli and international civil society who is collecting testimonies and putting them out there to the world. Probably have seen the very extensive report by B'Tselem, encompassing 55 different testimonies of people who've been held both in Sde Teman and in IPS facilities since the war, and encounter extremely difficult treatments that they've endured. The testimonies that we have collected corroborate some of those allegations. They corroborate, of course, the holding conditions in Sde Teman, which are the official policy that has been there for all this long, of physical abuse, of humiliation, of verbal humiliation. We at PCATI did not collect a testimony about sexual violence. I'm not saying it's impossible. It's very much possible. We've also seen the actual indictments filed against Israeli military reservists for the allegation of sexual abuse of a detainee in Sde Teman. So, of course, some of those instances indeed have happened, but I can't testify directly to that because I want to be clear on the information that I do have and don't have. But I would say generally, when you hold people, if you ask how is that possible or how did it come to this, I think we should look at three things. It's a combination of, firstly, the Israeli tragedy on October 7th and emotions of fear, of hatred, of paranoia, of disgust from seeing indeed the actions that the military groups that invaded Israel on October 7th have committed. And Israelis have been exposed to a lot of that, to a lot of video, to a lot of testimonies of very, very difficult acts towards minors, towards women. And that infiltrates into the mindset, I think, of every Israeli since. So you take that. And then you take some Israeli leaders who incite against that population, who use extremely derogating and dehumanizing terms when speaking about them. And I'm mostly referring to Itamar Ben-Gvir, the Israeli Minister of Interior Security, who is also in charge of the IPS. He's the minister in charge of most Palestinian detainees. And he has repeatedly said that his goal, his political aim, is to make their lives as miserable as possible because he sees them as less than human. And this has been repeatedly stated by him, and he never took it back either. So there's a green light, you could say, from some key Israeli leaders to dehumanize detainees, to avenge the Israeli victims through abusing them. And thirdly, you have a system that both leaves those people outside of the protection of the law because they're held in secretive camps, because there's no access of the outside world to them, but also because, and this goes far beyond and before October 7th, Israel has a culture of immunity towards acts of torture. People who have tortured detainees in the past, in other contexts, went unpunished for decades. This is an understanding. This is why we speak of a culture, because this is a conspiracy of silence, you could say. People know that they're going to get, most likely, unpunished. And this is crucial, I think, for people to take the law into their own hands or to unleash such sadistic, I think, attributes of our nature. You have to know that you would go unpunished. And the last issue in Sde Teman, this indictment that we saw, is actually the odd one off. I mean, this is the exemption, not the rule. The rule is that most of the complaints that we've filed for instances of torture have gone unchecked. In the past 20 years, our numbers show that out of 1,450 complaints of torture filed to the Israeli Ministry of Justice, 0 cases have reached indictments. And this is before October 7. Only in 3 cases did those complaints even go through a proper criminal investigation. This is the scale of immunity that Israel currently awards people who commit torture. So you can imagine how that has even more drastically changed to the worse since October 7, and also Israeli public mentality and public emotions that I've described.
Before we go into the complaints that you filed and some of the legal action you've taken, we're talking now about this detainees, the camp that is kind of the exception because there is a claim about it and it is being investigated. This is a detention camp in southern Israel. Some 4,000 detainees went through it, you said, and now only 24 remain. There are reports that 35 have died. And one man has described being handcuffed, blindfolded, and detained in a metal cage for 42 days. During interrogations, he says he's been given electric shocks and set upon by army dogs that scratched and bit him. Are these the kind of reports that you get from that camp? Is that in the investigation?
Well, firstly, the policy of holding all detainees in Sde Teman, all the many thousands of people who've gone through there, blindfolded and handcuffed and made to kneel on their knees most hours of the day in open-air cages on the ground, this is not an incident. This is the policy. This is the way people have been held under military orders for months and still are. And we can learn that both from official Israeli statements, like the Israeli response to the multiple petitions to the Supreme Court. They call it preemptive measures, and they claim the decision to apply them was taken individually based on an individual risk assessment. But every person who's gone through Sde Teman and has gone to take an interview on CNN or to talk to us or to talk to other human rights groups, and also Israeli whistleblowers that have come out to describe the situation in Sde Teman, all of them is described the same. So we know this is a policy, and this is something that every person gone through Sde Teman has endured. And to itself, I think, is just horrific. And beyond that, the arbitrary use of violence, of humiliations, of sexual violence is also something that repeats in multiple testimonies. So we definitely cannot and should not treat that as an isolated incident, but rather as a mechanism, as a system that has been operative there and still is.
You've been mentioning your own litigation in front of the Israeli system, and I've been thinking a little bit about the interplay between litigation and evidence, because you take evidence from people, you do litigation in order to, that actually opens a window. Sometimes as well, you find out more through the litigation. Then there's open source footage, video footage. Even some of the IDF reservists are uploading themselves, or other whistleblowers from within. Again, can you guide us through what's the combination of stuff that you have, and how do they play together?
So I would say that was a huge challenge in the early days, early weeks and months of the war, because we had a lot of concern about what's happening in Sde Teman. We looked at the secrecy and the legal framework that it's operating under, but we had no access. Nobody even heard the detainee to come out of there. So we had a lot of concerns, but zero information. What we then decided to do strategically was to attack the constitutionality of the law. We said, just look at the legal framework. Never mind what's the actual conditions. The legal framework in itself is illegal, is unconstitutional, violates international law standards. We've done that to kind of make up for the gap in information that we knew would be filled later on, but we just didn't want to waste time. We didn't want to wait until we have those evidence. Wait until we have access, if we have access. So this is why we firstly decided to attack the law strategically on the constitutional level, just on the level of the policies and procedures it sets in place. Through that petition, finally, information became available, because in the first months of the war, Israel would not even say how many detainees it held, how many people were detained. It's only through those litigation efforts, and I would say not just by PCATI, There is a very vibrant Israeli civil society, and there's been over a dozen legal petitions on various aspects of detention since the onset of the war. And all of them have contributed towards more information being revealed and indeed to the pressure on decision makers to start closing the camp. The reason that we have now 24 people in Sde Taman and not thousands as we've had earlier in the war is a direct result of those legal efforts, together with international pressure, together with media attention, but it played a key role because Israel, I think, gradually understood these acts are undefendable legally. What we can do now legally with the direct testimonies, with the power of attorneys we finally have, with the access to the victims themselves, is multifaceted. I mean, firstly, we can, of course, file individual complaints, and we will. And to our, I wouldn't say surprise, but we're very pleased to see that detainees wanted us to file those complaints, wanted their voices to be heard, wanted accountability. Because after what they've endured, you could imagine that they would also be very cynical towards this entire system. But no, most people that we visited with wanted their stories to come out, wanted their voices to be heard, and wanted complaints. So this is on the individual level, and we would definitely seek redress for each victim and seek accountability. And the second thing that we need to look into, and we have already called on, is for the ICC to intervene. And the fact that we've seen in the Office of the Prosecutor's announcement on the grounds that he would seek arrest warrants for and not mentioning detainees was to us disappointing, because I think the information was already available at that point in time of the scale and the gravity of the human rights violations, of indeed the war crimes, if not crimes against humanity, that are being perpetrated at the Israeli detention sites towards Palestinians from Gaza. We still do hope that the OTP would consider implementing that into the legal procedures, and we would, of course, do our best to support that effort, because we think that relying on the Israeli legal system to actually look into that, to hold anybody accountable, is just unrealistic, and we urgently need international intervention to stop those violations.
You've mentioned already that it's unrealistic to assume that the Israeli legal system will fully address the issues that you're all raising. Why still operate within that legal system to bring your complaints? And how do you justify to your clients, the people you work with who've been detained, that this is important that they do this?
So this is an excellent question. And when PCATI approached the ICC for the first time about 2 years ago, when I met Janet here at The Hague, this question was directed at us by both Israeli colleagues, Palestinian colleagues, and international stakeholders. The reason that PCATI still approaches the Israeli legal system and not boycotts it and focuses solely on international tribunals is firstly because, as Israelis, we hope the system will change. And every complaint that we file and every petition that we file give the system a chance to do better, to intervene, to change prior negative precedents, to hold people accountable. We would be happy to be wrong, and we would be happy for the Israeli legal system to prove complementarity exists. We see that as part of our role to play as civil society. So this is the first reason why we keep filing complaints, as well as strategic litigation, principal matter litigation. The second issue is more practical, to prove that complementarity indeed is not satisfied. In strategic instances, in instances of law, I think that's less necessary, right? If the Knesset, the Israeli parliament, approved the unlawful combatants law, and we believe that in itself this constitutes the war crime of enforced disappearance, there's no complementarity to prove. This is the law. But with individual complaints, it could be argued that we should have gone through the mechanisms to prove lack of complementarity. This is why back in 2022, when we approached the ICC for the first time, we have listed 19 different cases of torture and abuse that were treated by us, and all of which the complaints have been dismissed without criminal investigation. So there it was very important for us to prove lack of accountability and to show how that has not been met and why the ICC should in fact intervene.
Yeah, the ICC might be one of the fora. I understand that it's partly also to put pressure on the Israeli authorities, but there's also other forms of international pressure. We've just seen that the United Kingdom has suspended 30 arms exports licenses, and in detail, it said it's partly because of the alleged maltreatment of prisoners and potentially the not following of international humanitarian law, and the not allowing access by the International Committee of the Red Cross, which is not being allowed into these areas. How important do you think that kind of pressure is also from abroad?
It's paramount. It's critical and it's important, and it has a great effect, especially considering that this is the UK and the former administration. The UK was actually involved allegedly by Israel in an attempt to bypass the obligation of Israel to allow ICRC access. The cabinet has even gone to publish a decision where it claims that the UK would help Israel build this kind of visitors mechanism with British diplomats to bypass or to satisfy the request for external oversight of the military camps. So to go from that, from UK perhaps complicity even, in bypassing such human rights violations, such international law obligations, to a 180 angle shift to actually call out Israel, and that is significant. And it's felt. You could definitely see that this puts the Israeli decision makers under a lot of pressure. I think it would go a long way in Israel finally allowing ICRC access, which I think is the next thing that Israel must do. And I think Israel understands that too. Yeah, it's very welcomed. It's very significant, could go a long way.
I know you've hedged what you've said, Tal, but I think we should also make clear that the UK probably denies complicity in stuff in the past. But let's see what comes out in further investigations and see what's said. Steph.
It's not exactly denying it. When David Cameron was the Minister of Foreign Affairs, he said that we have offered Israel a kind of a deal because we think it's the lesser of two evils. He's gone on record to say that. So I wouldn't say it's entirely in the shadow of diplomacy and secrecy. We've had corroboration from the UK about those attempts. But as said, this is an attempt that did not succeed, both thanks to domestic litigation held by our colleagues at the Association for Civil Rights Israel and by massive international pressure, to which I'm very happy the UK is now joined rather than opposed.
And there's now a lot of international outrage about the things that happened after October 7 and these camps. But what about the long-term issues that you've already mentioned? There is the use of administrative detention, which apparently is also from an old British colonial law that is used by Israel to detain people without charge or trial and can be renewed indefinitely. That's already been going on a long time. How has that use of that exploded since the intensifying of the conflict since October 7? And how long have you been fighting against that? And what has the progress been from your side?
So administrative detention has been with us since as long as the occupation has been with us. And human rights organizations in Israel and abroad have tried to advocate against that, to litigate against that, to represent individually. Our colleagues at Hamoked represent hundreds of administrative detainees each year. Our friends from Adamir do the same. It's extremely difficult to really give any legal redress to those people because under the veil of secrecy, and I can say that because I've been there as a lawyer standing in the Supreme Court arguing for the release of a person that I have no idea what are the allegations against him, no clue of the evidence. Extremely frustrating. And indeed, as you said, Stephanie, the concern is that what has become a precedent in wartime, an emergency situation, would stay with us. And if before October 7, the highest amount of administrative detainees was 1,000 people, and that was a record of a year before, of 2023, we're now looking at more than 3,000 administrative detainees like it's nothing, like it's a new standard since the war. Now, of course, Israel can argue and is arguing that it's a state of war, that there are many people who are attempting to harm security, to indeed, attack Israelis and therefore have to be placed under administrative detention to prevent that. But the use of administrative detention at such a scale is in fact something that we worry would stay with us, because the arguing security risk and not giving evidence is the easiest you can do. And everyone who worked on human rights and counterterrorism knows how easily that word is tossed around and unchecked for. So yeah, we're very much concerned with it, but I would say, honestly, legally to challenge the administrative detention regime would take a much deeper overhaul of the entire legal system built by decades of occupation.
You've already mentioned, Tal, that you were in The Hague a couple of years ago, kind of talking to the ICC. That's where we met, and you were talking to them about torture allegations then. We've got torture allegations now. We're waiting still at the moment, as we're recording in September, for the proposed arrest warrants to be approved or not approved by ICC judges. But I'm wondering, from your position, what effect would you expect if those arrest warrants are approved to have, maybe on the broader Israeli society, but more specifically on Israeli judges, on the domestic judiciary? Will they listen? Will they take that into account? Does it count for something in Israel if that's the case?
Well, firstly, I would say that just the mention of arrest warrants had an effect on the Israeli judiciary. While in the early days of the war, we've seen very negative decisions handed down, very dismissive of human rights, of international law, we've seen much different decisions later on. So I think the gradual effect of international pressure, specifically international legal pressure by both the ICJ and the ICC, already has a positive effect, I would say, for human rights visibility in the Israeli judiciary. But what would happen once Israeli leaders face arrest warrants? I can say one thing that I'm very concerned with is legislation already proposed to make any engagement with the ICC a criminal offense. And this is something that has been with us for several years, but now a new proposed legislation has been put forward already in the last session of the Knesset to make any submission of evidence, any approach, any kind of assistance, any kind of technical assistance, anything to do with the ICC, a criminal offense of up to 7 years in prison. Obviously, that affects us at PCATI and me individually, I could say. If the Knesset would go as far as actually legislating such extreme laws, we would be in a whole different universe of human rights work in Israel. So that's one concern. And how would that affect the Israeli public? I don't know. I think the Israeli public has been so desensitized to international criticism that it wouldn't change people's minds. On the contrary, it would just make people believe that the whole world is against us and those institutions are biased. It's not going to change Israelis' minds and hearts. And that's okay, because the issue is justice. The issue is accountability. And this is what we keep in mind, even as Israeli activists, should those arrest warrants come to light.
Tal, I want to say thank you very much for your help and making time to have a chat to us. One of our last questions that we try to ask is, are there any specific court cases that you like to refer to when you're teaching or when you're talking to people that you think are really important for people to know the details of, and that you think it would be important for our listeners to look up, that's one of the crucial cases for people?
Absolutely. And gladly, both of them are legal precedents set by PCATI within the Israeli legal system. The first is the 1999 Supreme Court decision, PCATI versus the State of Israel, a landmark decision where the Supreme Court has in fact announced that torture is absolutely prohibited in the Israeli legal system, but at the same time created a legal loophole called the necessity defense, or the ticking time bomb situation, which is part of the reason why torture still is with us in Israel and still is a part of our security system, unfortunately. I think it's a crucial case for legal experts interested in human rights and counterterrorism to know. And the second very interesting ruling that I believe also has been translated into English is the unlawful combatants law from 2008, because the court analyzes how in its mind the law doesn't create a third category of persons, that no one can be outside the protection of the law, but also that the legal framework built in the original law should be the absolute maximum even in emergency times. And to see that very compelling decision, despite our very big criticism over it, being thrown out the window so easily since October 7 by Israeli legislators, I think is just astonishing. So I would highly recommend reading those two verdicts for those interested.
Our final question is always, is there anything that you would like to recommend to our listeners that you are reading, watching, or listening to? So what's on your podcast queue? What do you watch on Netflix? And what are you reading? What's on your nightstand?
Well, to dive deeper into the legal situation and human rights situation in Israel, I would highly recommend reading 972 magazine. It has excellent exposés that I think are extremely crucial, and also brings a different type of voice from the Israeli society that I would love people around the world to hear and to understand. It's a very complex society, and we have different opinions and different types of activism, and I would strongly recommend 972 as like a picking point to start understanding that, and also to hear very interesting exposés and narratives from the field. So this is something I would recommend.
Yeah, that's something I also recommend. I read a lot of them.
Tal, thank you so much again for making the time for us, and expect to see you in The Hague sometime.
Well, maybe sooner rather than later.
Oh, that sounds interesting. To be continued.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie van den Berg. This episode was produced in partnership with justiceinfo.net, an independent site covering justice effort for mass violence. Music is by audionautics.com, and you can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.